Jerry, we're going to be doing a podcast and to everybody here, at least every week until the end of the year. And I thought that the best person to do this, of all the friends and people who cooperate with the Latino Leadership Institute, I thought that you were the right person to have the first conversation through this podcast for a couple of reasons. First, the election was last week, the midterm elections. You are an expert on elections, not only in New York, but nationwide. Number two, this is a very particular type, this was a very particular type of election in which, and it's not the first time in history, because I know that you're a history student still, but this is the first time in a long time that the Supreme Court becomes a player in the election based on the Dobbs decision. And also other cases in which they have become players in elections since the Citizens United decision in 2011, Shelby County, that came right after that one. And there are some cases that the Supreme Court is already considering that are going to continue transforming the way elections are conducted in the United States if they have a majority of votes to make those changes, which it seems that they will have it. There is a big decision on December 7th, a hearing in the Supreme Court on December 7th. We're going to discuss that case. There is affirmative action that took place a couple of weeks ago. I heard, that I follow C-SPAN. I'm a fan of C-SPAN. That's how boring my life is. And so they are part of the electoral process, whether you like it or not. So anyway, and I thought that you were the best person to start our first podcast talking to you with your expertise. But first, something that we wonder at the Latino Leadership Institute, where you teach, and you have been teaching with us for 12 years, Jerry. You have never said no, and that is something that we all appreciate, to have the best lawyer considered by many in the state of New York and one of the best lawyers in the United States to come and teach a class on the petition process in New York in order to get registered to be able to run for office and get those signatures and say, these are the people who support me, etc. And to have you is a great honor for all of us, but especially for the students. So that's why you're here, and also to say thank you to you for all these years that you have been working with us.
Well, thank you for putting together the Latino Leadership Institute 12 years ago. And it's always been my privilege and pleasure to join with you in teaching that class and meeting the students, some of whom have gone on to elective office, some of whom have gone on to law school,
yep,
and many of whom who have been involved in political campaigns in one capacity or another. So I've always been thrilled to be part of that. But I will say that in the beginning, the first few years were a lot better than more recently, because your daughter used to bake cupcakes for me when I would come on Saturday morning. So now you have to buy them, which is not exactly the same. So in any event, it's good to be here with you today.
Well, that's a promise. We're going to send you a badge. Thank you, Jerry. So, Jerry, so this is the first thing. Something that we always ask is, how did you decide to become a lawyer? Very simple question, very personal.
I would say together in an email.
Okay, so
you're going to say with the letter.
Okay, someone is. Can we put everybody mute except Jerry? Carmen, we can hear you. Can you put
No,
yourself in
no,
mute?
now she's on mute.
Okay,
So
good.
how did I become a lawyer? Why did I decide
Yeah,
to become a lawyer?
what happened? What was the accident that happened on the street? Someone hit you? What a lamppost fell on you and you said, I'm going to sue this,
Well,
whatever it was.
in part, it has to do with when I grew up. I grew up during John Kennedy's presidential campaign. I was 13 when he ran for president, and I became very, very interested in what he was doing as president. I knew all the names of the cabinet members at the time. I don't know that I know them now. And I got very involved with the Bobby Kennedy presidential campaign. I decided that it was a real opportunity to become a lawyer. I'd really be able to try to affect the world and make it better. At first, I studied political science, and I got a graduate degree in political science. But I realized that I would combine my teaching with becoming a lawyer. And so far, I've had an opportunity to advise many, many candidates running for city council, for president of the United States, for governor, for mayor, people who also think that they can really make a difference, and I have the opportunity to help them. So it's just a terrific credential to have, and it's a terrific opportunity to actually be able to assist people in their dreams to run for office, or in their campaigns if they're managing them. And I just had a phone call, so forgive me, I shut it off. So that's the reason why I became a lawyer, and that's why I love doing it.
Okay, one more thing, more still in the personal aspect. Is there any case that is always with you of all the hundreds and cases that you have dealt with, that you still remember, that had an impact on you? And this is important because, you teach, I teach, and something that we always find in our students is that there is always something outside the classroom that teach them more than we can teach them. And those experiences that, that we go through life, was there a case that basically said to you, I definitely selected the right profession, or maybe I'm not sure because of this, but there is always something that you remember all the time that you always said, this is why I'm here?
Well, I hate to disappoint you, but there's no one case that propels me to continue doing what I'm doing. I've had so many cases relating to people trying to get on the ballot, or people trying to comply with campaign finance laws or voting rights laws, redistricting, and so on, a variety of different kinds of government cases. So I think more than anything else, it's the people I represent, the candidates or the elected officials. When I sit with them and I talk to them about their campaigns, when I talk to them about their dreams, when I talk to them about what they want to accomplish, that's really what gives me a lot of satisfaction.
Okay. Thank you, Jerry. Now, I want to, elections have changed dramatically since it's not that it happened only once. Throughout history, there have been new laws, etc., that have affected the way that we run elections, issues of First Amendment, 14th Amendment, etc. But in 2011, the Citizens United decision came about from the Supreme Court, and it changed how we donate monies. Before, you make your donations. Now corporations are people, according to the decision that says that corporations have a First Amendment right, like individuals, like human beings, in order to contribute to campaigns like any other person.
Well, so let me say that the two cases that you mentioned earlier on, when we started this webinar, were the Citizens United and Shelby County. Citizens United related to what you just were talking about, how people contribute, corporations and unions contribute to campaigns, but they don't contribute to campaigns necessarily. They contribute to organizations that impact campaigns. It's the significance of the Citizens United case is that corporations and unions and individuals can give unlimited amount of money to independent expenditure organizations, not connected to the campaign. Independent expenditure organizations that on their own, separate and apart, uncoordinated from, not coordinated with the campaigns, on their own try to elect candidates or defeat candidates. You know, there are contribution limits to candidates, whether the candidate is running for federal office or state office or city office. But as a result of this case, there are no limits to what a corporation or a union or an individual can give to an independent entity. And that independent entity, this i.e., the Independent Expenditure Organization, as long as they're not coordinated with a candidate, can get unlimited amount of money and spend unlimited amount of money to elect somebody or to defeat somebody. So that's Citizens United in a nutshell. The second case, Shelby County, related to the Voting Rights Act. The Voting Rights Law, as passed in 1965 under President Lyndon Johnson and reauthorized time and time again, as recently as 2006, with huge majorities, bipartisan majorities in the House and Senate, signed by President George Bush. The Voting Rights Act permitted in one of its provisions, I should say not permitted, required in one of its provisions that if you live in a certain sections of the country, certain states or certain counties in a variety of states, including, by the way, 3 counties in New York, Manhattan, the Bronx, and Brooklyn. So if you're in Alabama, Mississippi, some counties in Alaska, and even in New York City, throughout the country, if there are any changes to your election laws or your regulations, they have to be, any proposed changes, they have to be approved by either the Department of Justice or a court. That's Section 5, that's that provision of the Voting Rights Act, passed in 1965, and reauthorized and reauthorized and reauthorized again through 2006. For 25 years it was supposed to be. The Supreme Court of the United States said that the formula that Congress set up by which we identify which jurisdictions have to go to the Department of Justice in order to get their proposed election law changes approved, the formula by which we identify those jurisdictions is outdated. It was okay in 1965, but the world has changed, and therefore Congress, you need to pass a new formula if you're going to have certain states or certain counties have their changed election laws approved by the Department of Justice. So they didn't strike down the procedure whereby jurisdictions have to get approval of election law or regulations approved by the Department of Justice. What they struck down was the formula by which these jurisdictions are identified. But as a practical matter, it means that we don't have that provision operational any longer. We don't have that Section 5 of the voting rights law, in effect, which means Alabama, Mississippi, New York City, all the states and counties throughout the United States that needed approval by the Department of Justice didn't need approval any longer. So immediately after the Supreme Court rendered its decision in this case, we had all sorts of states passing very restrictive voting rights laws, which has really been exacerbated over the last 9 years. We've had a slew of states passing restrictive voting rights laws throughout the country, and the Department of Justice can't do anything about it in advance to pre-clear it, to approve it. And the only thing the Department of Justice can do is to sue them after the fact. And of course, individuals can sue after the fact, after these laws are put into place. And so this vehicle, this avenue that the voting rights law gave us so many years ago and has worked so effectively in tamping down restrictive voting rights law is no longer, that avenue no longer exists. So now we have all these states passing restrictive voting rights laws, don't have to be approved in advance, and now people have to sue, or the Justice Department has to sue, which is very time-consuming and costly. And in the meantime, these laws are in effect unless there's an injunction that's issued, which is not always the case. So those two cases have had a real impact on voting in the United States. It's changed the campaigns. We have a lot more money involved in our campaigns, so-called dark money, where these independent expenditure organizations spend literally millions and millions of dollars, sometimes much more than the campaigns spend themselves. And it's so much harder for voters to vote in certain communities in certain states. So as a result of those two cases, between the money and the carte blanche that these states and counties have to put in effect these awful laws, we have a very different kind of electoral system now than we did even 10 years ago. And so I think it was really, it's good that you raised those two Supreme Court cases, because they have had such an important effect on our politics. And we have, I know you're about to ask me about a case that's coming before the Supreme Court, because you mentioned there's an oral argument on December 7th.
Mm-hmm. Yeah.
Which is seeking to have the court rule that legislatures can pass election laws on their own without any input of the state's courts or even the governor. So this goes to a constitutional provision that gives the states the authority and obligation to regulate their elections. It says that the legislature of the states regulate their elections. So this lawsuit is arguing, they say legislature, they must mean legislature. Opponents of their position say legislature doesn't mean just legislature, it means the legislative process, whereby the legislature passes a law, the governor either signs it or vetoes it. If they veto it, the legislature can override it. But in any event, someone can go to court and the Supreme Court will rule, Supreme Court of the state will rule, or the courts of the state, or even the federal courts could rule on what the legislature has done in the laws that they've passed relating to their elections. This case is saying
no. Yes.
it's just the legislature,
Yeah.
and the courts can't interfere. Well, if this Supreme Court of the United States rules in favor of what these plaintiffs are arguing, it's going to upend all of our elections, because state courts are not going to be able to protect the voters. Governors are not going to be able to protect the voters. It's going to be the Wild West if this Supreme Court adopts the view that's being brought to the Supreme Court. So people have the opportunity in real time to listen to the Supreme Court arguments. So on December 7th at 10 a.m.,
C-SPAN.
you can tune in. No, not C-SPAN, because they don't televise the Supreme Court.
No, they do the voices. You can hear it.
I didn't realize that.
Yeah, they put a picture, and they just share the picture for 5 hours.
Okay, fair enough. But you can go on the Supreme Court link and just click on the link and listen to this argument. And if you don't have the opportunity to do it on December 7th, because you're celebrating after December 6th, when Reverend Warnock wins, then you can listen later on afterwards to the Supreme Court decision, Supreme Court argument, rather.
So, Jerry, so this is the thing that occupies the mind of many junkies of elections and constitutional law, etc. We have Citizens United, then we had Shelby, and Shelby basically was Section 4B. Instead of going after Section 5, the preclearance itself, they went after the criteria.
That's right.
Of Section 5, and they eliminated that one to look like they didn't go after preclearance. I mean,
that's right.
Like, like people are stupid. But this is the thing. Now we have this case that is being presented, and they accepted. They could have said no to this ridiculous case, because even North Carolina went against it. So that's how it ended up in the Supreme Court. Do you think that we are in an era of extreme overreaching by the Supreme Court, getting into things that, for example, Shelby was approved by Congress 98-0
in the Senate.
In the Senate before it went to the Supreme Court, 98-0, through the democratic process, through deliberations, the people decided that. Then they come and they change it, 5 votes. So do you think that at this point we're in a very dangerous time? I think that we're in a very dangerous time in which the first thing that they teach in law school is that the law of the land is 5 votes. But it has never been more clear to me and to many that those 5 votes are really the ones running the country, especially in important decisions that have to do with the issue of democracy. Are they overreaching, or are they finding real constitutional grounds to make this decision, or they are just making it up?
Well, they don't think they're making it up, and the Dobbs case is another example. Exactly. Where they overturned 50 years of constitutional right of reproductive choice. You talk about 5-4 in the Shelby County. It's a small group of people. It's 9 people on the United States Supreme Court. Every vote counts. It was also 1 vote where the Supreme Court of the United States ruled that same-sex marriage was not unconstitutional, was that the states could have a same-sex marriage. So we won that by 1 vote. So sometimes you win by 1 vote and sometimes you lose by 1 vote. That's the nature of a court. But you look at this court and you realize what happened. The reason we're in the situation we're in is because under President Obama, the Republican Senate refused Merrick Garland, refused to even give Merrick Garland a hearing. They stole that Supreme Court seat, and the administration didn't do very much about it for a year. And then they rammed through Amy Coney Barrett when Justice Ginsburg died, even though people already had started to vote. So they were very hypocritical because they were so inconsistent. Yeah. They wouldn't allow Merrick Garland's nomination to go through because it was the last year of President Obama's presidency, but yet while voting was going on during Trump's reelection campaign, where he ultimately lost, of course, they rammed through a Supreme Court justice. So they're pretty hypocritical, inconsistent, and they took power because they could, which I think really makes our constitutional democracy fragile and on a precipice. Now, the midterm elections from last week gives us some relief that voters at least know how to put on the brakes to these election deniers, these seditionists. And a lot of them lost, although a lot of them also won. About 200 of these election deniers were elected throughout the country. So even though some of the high-profile election deniers lost, a lot of them won. And so we're still in a very fraught, fragile time in our democracy here, which is the lesson of which, the takeaway is everybody needs to continue to be politically engaged, because that's the only way change comes about. That's the only way institutions are shaped to be as responsive to the people as we want.
And Jerry, in case, because I know you are at the office and working, in case you didn't know, McConnell was challenged today, this afternoon, by, I think his last name is Chris, I forgot his first name, challenged for the leadership, not for the leadership in the Senate, because he's no longer, he doesn't have the leadership, but in terms of the leadership of the Republicans in the Senate. So he has a big challenge, and the forecast so far, it doesn't look good for McConnell. So, you know, I mean, just to let you know, in case you didn't hear the news, it just came out in MSNBC.
Well, he hasn't been beaten yet, has he? When are they voting?
No, they show the challenge was made. They're running against him. I don't know when the vote is going to take place. Who knows? But definitely.
Well, for all of you folks who are listening to this is already old news to you.
So, and then the other issue, and this is something that has been itching in my brain. Since Dobbs, since Citizens United, Shelby, etc., all these cases, especially Dobbs, it's an attack on the concept of stare decisis. And I don't know if that is good or bad. Stare decisis is basically that the court takes in consideration the length and the power of certain laws that were approved, constitutional laws that were approved a long time ago, and they treat them with the respect that they deserve. Not always has been like that. Plessy versus Ferguson was a decision that basically was eliminated by Brown versus the Board of Education, meaning that separate but equal didn't exist. That was stare decisis, but that stare decisis went out of the window. But now we're having all these cases, especially the Dobbs case. And I'm wondering, Jerry, and I'm asking, for your wisdom on this and your experience, do you think the stare decisis is dead?
No, I think that they will ignore, the court will ignore it, or a majority of the court will ignore the doctrine of stare decisis, where you have to follow precedent. They will ignore it when they want to, under certain very extreme circumstances. But for the most part, they won't. For the most part, they will follow stare decisis. They will apply stare decisis, and they will follow precedent.
Okay. So, Jerry, two more cases, and then I let you go. They're the affirmative action cases. I don't know you found, because it's not necessarily in terms of elections, but you're a professor, I'm a professor, I teach, and many of my students benefit from affirmative action. There were two cases that were presented to the Supreme Court, one from Harvard University. That case basically is private institution, and then the one from North Carolina, I believe that it was a public university. So they had a public and a private university, but they, during the hearing, I didn't see them making a distinction between the two of them, at least not clearly, and if they did it, I completely missed it. And that will be another hit after Dobbs, especially on women too, because women, especially white women, are the ones that benefit the most in terms of affirmative action. The statistics are very clear. And before that, there was a case called Fisher, and a Harvard case before that, that basically said, we take in consideration race. It's not the determinant factor to accept people, but we have like 50 different codes or factors that we take in consideration, and race is just one of them. Then there is the issue of legacies, like Harvard, Yale, that Columbia, that law schools that have this, if your father or your mother graduated from here, and we give you extra points, but that is not in that equation, but that had existed forever. So what do you think, where we are with this, with this Supreme Court in terms of affirmative action? Are they going to get rid of it, or are they going to make a distinction between public and private universities, and let the corporate universities do whatever they want, but not the public universities? What do you see?
The short answer is I don't know. I think they were really grappling with these issues during oral argument, and it's hard to predict how they're going to come out. It's easy for us to say, oh, well, it's a conservative Supreme Court, and therefore they're going to strike down affirmative action in any form, or maybe they'll just trying to look good, they'll do it for one but not the other. It's hard to know what they actually will decide. It's always been a very tricky issue before the courts. That's the best I can do on that one.
Go. And then the last one that I had, you went ahead at the beginning and you attacked it immediately. It's basically the case about the state assemblies taking control of the elections. And Jerry, an advice, if I may, that you can give us. We have been doing this for 12 years. Anything new, be open, don't worry, that you think that we should do at the Latino Leadership Institute. By the way, we have 4 assembly women from the Latino Leadership Institute. The chief of staff of the majority leader in the assembly was one of the first students of the Latino Leadership Institute. She used to work for Vanessa Gibson. She was just a staff person, low staff person. Now she's the chief of staff of the majority leader. And don't ask me the name. I usually try not to pay attention to the state. We have 2 council members, and in Florida, we elected 9 people to office in 3 years, 9. So, and all that for free. I have to say, because nobody gets paid here. We depend on the volunteer work of people like Jerry and others. Mike Nieves is going to come here. The smartest man in the room is going to come in a couple of weeks. And we have all this talent, the best teachers in elections working for us, and they don't charge us and we don't charge the students. So Jerry, any advice that you can give us in terms of how to proceed or make any changes? Don't mention the podcast because this is new. We're already in.
Well, I genuinely think that what the Latino Leadership Institute has been doing has been terrific. You know, I feel that way. And the only recommendation that I would make is to go to where the students are. Have sessions on CUNY campuses in Brooklyn, in Queens, in the Bronx. You'll get more students that way, and you'll learn more from what the students who don't come into the Manhattan venue, you'll learn more as to what they think. And I think it'll broaden your appeal. Yeah. You'll be able to reach a lot more people, and I think it'll be all to the benefit of the organization, and more importantly, what you're trying to do.
Okay. Thank you, Jerry. As we said, we're recording this. We're going to send it to everybody. I don't see anything here in the chat. Jerry, I don't want to take too much of your time. This is going to be short presentation.
No, listen, it's been my pleasure. It's always good talking to you and to the other people listening in. Stay engaged. Go to the classes. Learn as much as you can. Don't rely on the wisdom or the experience of other people. Learn it yourself.
Exactly.
So that you can become an expert in campaigns, in ballot access, in campaign finance. We need a much more diverse group of people who are experts in this area. So that's what motivates me to be involved, because frankly, there are only a handful of people who look like me, who are as old as I am, although I look older than I actually am.
Yeah, exactly. That's true, by the way.
And so I encourage you to learn the craft, learn the nuts and bolts of elections, of campaigns, become an expert. Everybody can become an expert, and you'll be better off.
And don't be afraid of making mistakes. Number one rule.
Absolutely. Absolutely. So thank you very much. Thank you for everything you're doing. Donna, say hello to Representative Cicilline for me.
Jingham, who else is there?
Yeah, I'm here.
Thank you so much. Jerry, big hug, brother. I wish I could hug you personally.
Same here, my friend.
We owe you a lot. Thank you so much. The biggest hug to you and your family.
Thank you.
Thank you, everybody.
My pleasure.
We're going to be sending this. We have 2,500 people in our mailing list. We're going to be sending this podcast and all the others to everybody by tomorrow. Most of you should have it, the whole videotape. And then next week, we're going to return with another one. We will announce it during the weekend. Okay.
Okay.
Jerry, thank you.
Thank you. Bye.
Okay. Bye-bye.